18 USC 242, Deprivation of Rights under Color of Law. From Title 18, Crimes and Criminal Procedure, Part Y, Crimes, Chapter 13, Civil Rights, Power 242, Deprivation of Rights under Color of Law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien, or by reason of his color or race, than are prescribed for the punishment of citizens, shall be fined under this title, or imprisoned not more than 1 year, or both. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title, or imprisoned not more than 10 years, or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title, or imprisoned for any term of years, or for life, or both, or may be sentenced to death. (18 USC) Paragraph 242, known as the Deprivation of Rights under Color of Law statute, is a federal criminal law that prohibits the willful deprivation of constitutional or legal rights by anyone acting under the authority of law. Here are the key elements of this statute. Scope. The statute applies to any person acting under color of law, which includes federal, state, and local government officials, e.g., police officers, judges, prison guards. Those acting in an official capacity, even if exceeding lawful authority. Private individuals collaborating with state officials. Prohibited Acts. The statute criminalizes willfully subjecting any person to the deprivation of rights secured or protected by the Constitution or federal laws. This includes depriving someone of their constitutional rights, e.g., due process, free speech, freedom of religion, discriminating against someone based on their alienage, race, or color by imposing different punishments or penalties. Penalties. The penalties depend on the severity of the violation. For a basic violation, the penalty is a fine, or up to 1 year in prison, or both. If bodily injury results, the penalty is a fine or up to 10 years in prison, or both. If death results, kidnapping, sexual abuse, or an attempt to kill occurs, the penalty can be life imprisonment, the death penalty, or any term of years in prison, in addition to fines. Key points. The crime is a willful deprivation, meaning it must be committed intentionally and with a specific intent to violate the law. Animus or discriminatory motivation is not required. The act itself is sufficient. The statute covers a broad range of constitutional and statutory rights, not just civil rights. It applies to both public officials and private individuals acting in concert with state actors. In essence, 18 USC paragraph 242 is a powerful tool to hold government officials and those acting under color of law accountable for willfully violating individuals' constitutional and legal rights with severe penalties for egregious violations.